Welcome to Cardamone Law University, translating the Pennsylvania Workers' Compensation Act into plain English for injured workers. It's Mike Cardamone here. Today I wanted to talk about 3 really important tips for injured workers in a Pennsylvania workers' compensation case. Remember, nothing on our podcast shall be construed as legal advice. You would have to sign our fee agreement to become a client of our firm. So you want to be careful and make sure you get lawyered up if you have a workers' comp case, either with my firm or another reputable workers' comp firm in Pennsylvania. It's really important to remember that. So think of these as just sort of general pointers. The first thing is be honest, and that goes without saying, right? Most people will tell me when they talk to me, "Hey Mike, I have nothing to hide. I don't know why you're telling me that. Of course I'm honest." But what happens is a lot of people, when they testify, for example, they get a little bit fatigued or a little bit intellectually lazy, and they start maybe overstating things out of emotion or fatigue. And the other attorney, you got to remember, we're experts with words, and the other attorney is going to use your words against you. And if you overstate something, they're going to pick it apart and put you on defense, and you never want to be on defense in a workers' comp case. So be honest, which also includes do your homework. Remember, jog your memory about prior injuries or prior treatment to the same body part that's currently at issue. You're going to be asked about it by the doctor, by the judge, by the lawyers. So don't get lazy and think, "Oh, I don't really remember when my car accident was." Try to do your homework and figure out when it was and where you treated. You're going to be asked those questions, and the answers won't hurt you as long as you're forthright about it. But if you leave something out and it comes up later, and when they subpoena your family doctor records for the last 10 or 20 years, they're going to make you look like a liar, because that's their job on the other side, is to discredit you and to make you look like you're not credible. So do your homework. That goes along with being honest, because you want to make sure you're giving somebody the correct information to the best of your ability. And sometimes you can't find information from a prior event, and that's fine. You can only do what you can do, but you want to make that effort. It goes a really long way. The other thing is you want to make sure you're keeping a low profile, okay? The insurance companies, again, their job is to try to pay out as little as possible and to discredit you in your case. How do they do that? Well, sometimes they hire surveillance companies to spy on you or to do an investigation of your social media. So if you're posting while your case is active on YouTube, on LinkedIn, on Twitter, Instagram, Facebook, whatever, it may present a picture, and perception can be reality. So you want to try to stay off of those platforms while your case is being litigated or active, even if it's not in court, but you have an open claim. They're going to be surfing through that information, and there's nothing unlawful or fraudulent about going to a movie or going to dinner or going to a family picnic, but sometimes they can spin that and make it look like you're really active, and then you have to explain it. You may not be doing anything inconsistent with your injuries. Maybe you went to the picnic and you sat down the whole time. Doesn't mean you were playing volleyball. But again, it can put you on defense, and you have to explain things, and you don't want to be in that position in a workers' comp case. So what's the bottom line? Well, keep inactive. And even if you're having a day where you don't feel a lot of symptoms, don't go outside and do anything physical. They're going to use it against you, and you're going to have to explain it. Doesn't mean there's surveillance in every case, but you don't know, when they're surveilling you. They're very good at it for the most part. So stay off social media as much as you can, and stay physically inactive. Again, we see people, we get surveillance video, and sometimes people are carrying, milk and bread from a grocery store. That doesn't mean you can do your pre-injury job, which may have required lifting 100-pound boxes or doing things really physical. So they're not inconsistent. But you don't want to be outside doing anything really physical, because then again it can put you on defense, even if it's not inconsistent with your injury or your disability level. The third thing would be to treat. Unfortunately, there's a perception that if you're not treating, you're either recovered or you're not as bad as you say you are, etc. That's not always the case. Some people have surgery for a work-related back injury, for example. They have the requisite physical therapy. Before that, the surgery, they may have had therapy and injections. And after surgery, they do their therapy and they level off. They reach what's called maximum medical improvement, where maybe they're just living, with some pain meds for breakthrough pain, but they're not really treating anymore because there's nothing else for the doctors to do. Unfortunately, when there's litigation, a long absence in treatment, again, that will be used against you. Doesn't mean you're going to lose your case, but it's just one factor out of many. But rest assured, the other side's going to harp on that and make a big deal over it if there's a big gap between treatments. So unfortunately, our system kind of pushes people into a corner in terms of treatment on a regular basis. It shouldn't be that way. I don't tell our clients to abuse the system and to go treat just to pump up the value of their case, but I remind them that if you don't treat, what the perception might be. So unfortunately, it's something to keep in mind, even if it's just an office visit to get a checkup every 3 or 4 months. That's a lot better than going 6, 7, 8 months without any doctor's visits. Again, can put you on defense. You have to explain it. Maybe nothing wrong with that, but perception can be reality. So these are 3 things to keep in mind. Be honest, of course, that goes without saying, but as a component of that, to do your homework, to really figure out if you ever had any prior injuries or treatment to the body part at issue, that can be really important. And remember, an aggravation of a prior condition is still a work injury, so it doesn't hurt your case. It will hurt your case if you leave it out and the insurance company or their attorney finds out later that you left it out, because they're going to try to paint you look like you're not a reliable person. And again, surveillance, be smart, social media, try to stay off it, those kind of things. And the third thing we talked about was treatment, and try to be, regular with treatment and follow through with your appointments. If you have any questions about Pennsylvania workers' comp, call us. We're a unique, rare law firm. That's all we do. 100% of our practice is for injured workers. You can call us anytime you want, 7 days a week, 215-206-9068. That's 215-206-9068. Or you can email Michael at cardamonelaw.com. So MICHAEL at CARDAMONELAW.com. If you want our website, it's cardamonelaw.com. You can also get there by myphillyworkerscomp.com. That's all for now from Cardamone Law University, and we'll talk to you soon. Thanks. Bye-bye.